sometime later. So my topic is Multiculturalism Good for Women? An analysis of Indian state practices after the Shah Bano judgment. So, in academic writings on Indian multiculturalism, the Shah Bano controversy is a threadbare example of the incompatibility between gender equality and religious autonomy. This paper is an examination of the Indian state practices in the aftermath of the Shah Bano controversy in accommodating demands made by the requirements of Muslim personal law and the concerns raised by demands of gender justice. The argument advanced in this paper is, after the Shah Bano judgment in 1985, state practices in India have shifted away from prioritizing either religious autonomy or gender equality to accommodating both religious autonomy and gender equality. So what I will do here is that through an examination of case law on maintenance of divorced Muslim women after the Shah Bano verdict in 1985 and the promulgation of the infamous Muslim Women Protection of Rights on Divorce Act in 1986, I'll call it the MWA, I examine how the judicial branch of the Indian state has accommodated demands of religious autonomy and concerns of gender justice. So in my analysis of case law, there are two important Supreme Court cases. First is the Muhammad Ahmad Khan and the Shah Bano Begum judgment of 1985. And the next is the not so famous, not many people know about it, the Daniel Latifi versus Union of India 2001 judgment, which examined the constitutional validity of MWA. And between these two judgments is what I call the liminal period, is between 1986 to 2001, where while the constitutional validity of Muslim Women's Act was being challenged through several petitions filed in the Supreme Court, the high courts were interpreting the act. So meanwhile, between 1986 to 2001, the high courts were interpreting the act in contradictory ways, with some providing maintenance and provision amounts beyond the iddat period, and others providing maintenance and provision amounts restricting within the iddat period. So I don't know if everyone here knows what iddat period is. It's a 3-month period in Islamic law where women, after divorce, you get 3 months to mourn or to ascertain whether the woman is pregnant or not. So during that time, the status whether she is divorced or married is not really. So it's a it's a period in transition, you can say. So by analyzing the case law on maintenance of divorced Muslim women in the High Courts and the Supreme Court of India, I examined the claim of scholars like Narendra Subramaniam, Flavia Agnes, Werner Mensky, who have argued that the way the MWA has unfolded shows that Muslim personal law can be gender just. So my question is, if the judiciary is providing a gender just interpretation of the 1986 Act, the two interrelated questions need to be answered. First, in providing a gender just interpretation of Muslim Women's Act, is the judiciary prioritizing gender justice at the expense of the demands of religion, or has the judiciary found a way to balance both the demands? If it's the first case, then why haven't we seen any conservative backlash from the Muslim community so far, the kind we saw during the Shah Bano case? If it's the second case, then a second important question to be asked is, how has the judiciary balanced the demands of religion and gender justice? So I'll just briefly outline the structure of my paper. In the first section of the paper, I will just briefly mention how Section 125, that is part of the criminal law, came into conflict with Muslim personal law after its amendment in 1973. In the next section, I will analyze the Shah Bano verdict of 1985. The third section is an examination of High Court verdicts of maintenance of Muslim divorcees in the liminal period, that is 1986 to 2001. And the fourth section, I analyzed the Daniel Latifi verdict, where the Apex Court took up the issue whether MWA is constitutionally valid. And in conclusion, I will critically assess the legal discourse on which gender just interpretation of MWA is based. So the first part is the secular law versus the Muslim personal law. The secular law, that is the criminal law, and how it came in conflict with Muslim personal law. In 1973, an amendment was made in the old Code of Criminal Procedure, 1898, in which a husband was obliged by law to provide maintenance for his ex-wife and children. Now, what happened that after this amendment in 1973, Section 125 of Code of Criminal Procedure came in conflict with Muslim personal law. What happened that under heavy political pressure, the Congress government introduced the MWA, or the Muslim Women's Act, in 1986, right after the Shah Bano judgment in 1985. This MWA restricted Muslim women's access to Section 125. As per the Act, divorced Muslim women cannot seek protection against destitution and vagrancy provided under Section 125 to 128 to all other women of all religious communities except divorced Muslim women. So yeah, it was discriminating against a particular section of women based on religion. And the Act also does not have an exit option for Muslim divorcees who wish to be governed by the general law. So this Act was actually challenging the secular conceptions of Indian secularism. But what has happened over the years, we will see that personal laws actually are not very different from, like, the way the judges have pronounced judgments. All the personal laws look similar. So there is no discrimination against Muslim women, and I'm coming to that now. So before, I'll just briefly talk about the Shah Bano judgment. I think everyone knows about it. The Shah Bano case basically had to settle the thorny question whether there was any conflict between Muslim personal law and secular provisions of Section 125. In this judgment, the judges noted that under Section 125(1)(a), if a person with sufficient means neglects or refuses to maintain his wife, who is unable to maintain herself, he can be asked by the court to pay a monthly maintenance to her with an upper limit of 500 rupees, which is less than $100. In Clause B of the explanation of Section 125, wife includes a divorced woman who has not remarried. This requirement to maintain ex-wives was contested by the appellant, that is the husband, Muhammad Ahmad Khan, to be against Muslim personal law. The judiciary noted that since Section 125 is part of the criminal law, the religion professed by the spouses has no place in the scheme of these provisions. The judges noted that Section 125 was enacted to provide remedy to persons who are unable to maintain themselves. Since this section is based on concerns of social justice, religion here had no role to play. The judges contended that, and I quote, Section 125 overrides the personal law if there is any conflict between the two, end of quote. Thus, the judgment clearly maintained that social justice comes prior to religious demands. The judges further argued that the liability imposed by Section 125 to maintain close relatives who are poor is founded upon individual's obligation to the society to prevent vagrancy and destitution. This, the judgment maintained, is the moral, and I quote, is the moral edict of law, and morality cannot be clubbed with the religion. Now, Bano observes that since late 1980s, there has been an expansion of judicial domain in the family law. During this period, he argues, there is a subtle gradual shift from the demands for a universal civil code, and despite this, there has been what he calls harmonization of personal laws. Mensky contends that the main new message of uniformity is that all Indian men, as controllers of most of the property and resources in India, are primarily liable for the welfare of wives and children who are in need of support. So, despite the bugle call for an imposition of the Uniform Civil Code in the Shah Bano judgment, which later became the highlight of the judgment, the Supreme Court attempted to harmonize the Muslim personal law system with the secular law by invoking social welfare concerns, which, to quote the judges, cut across barrier of religion. Further, in order to demonstrate that Section 125 does not conflict with Muslim personal law, the judges involved themselves in religious exegesis, which, as we all know, became one of the main reasons for the Shah Bano controversy. The Supreme Court judges contended that the appellant's argument in Muslim personal law, that in Muslim personal law, the husband's liability to provide maintenance to his divorced wife is limited to iddat period cannot be accepted where the divorcee is unable to maintain herself. Thus, the judges argued, and I quote, the true position is that if a divorced wife is able to maintain herself, the husband's liability to provide maintenance for her ceases with the expiration of the period of iddah. If she is unable to maintain herself, she is entitled to take recourse to section 125 of the code. End of quote. To show that this true position in Quran does not conflict with Muslim personal law, the judges went on to interpret and reinterpret Islamic laws. So what happened then, that the judges therefore quoted verses 241 and 242 of Quran to show that the Islamic concept of fair and reasonable provision, which is called Mata'un bil Ma'rufe, there is an obligation of Muslim husbands to provide for the divorced wives. Now, according to Pratap Banu Mehta, the Indian judiciary has involved itself in an act of reinterpreting and regulating the meaning of religion in order to square the constitutional dilemma of protecting liberal constitutionalism and at the same time protecting the right of religious freedom. He argues that, on the one hand, constitutional practice requires religion should be made subordinate to public purpose. On the other hand, constitutional practice also requires that these public purposes do not impinge upon religious practice. Mehta contends that the only way to achieve this happy congruence is by regulating and trying to control the meaning of religious doctrine. Thus, through the process of internal reasoning and argumentation, Indian courts have sought to establish that the requirements of justice have a basis in different comprehensive doctrines. In other words, for the Indian judiciary, since the demands of justice are not opposed to demands of religion, not only are different religious doctrines compatible with each other, there is also no serious disagreement between religious demands and demands of justice in secular law of the state. So, this analysis from the Shah Bano judgment, it demonstrates what I call a dual process of harmonization of Muslim personal law with the secular state law undertaken by the judiciary to balance demands of religion and gender justice. Thanks. So this dual process of harmonization is, there are two strategies. The first is what we saw is the Mensky way, where the judiciary invokes social welfare concerns and tries to harmonize the personal laws with the secular law of the state. So they'll say, because of social justice comes prior to religion, therefore, we cannot allow this in this religion. So that is the first process. And the second harmonization process is the Mehta way, where Pratap Banu Mehta, as I just showed, said that what the judiciary does, what the state does, is tries to interpret religion in a way that is in congruence with the secular law. So they say, oh, there's no serious disagreement. What the constitution says and what the personal law says is the same. So there's actually no conflict between personal law and secular law. So these are the two, this is the dual process of harmonization, which we saw in the Shah Bano case. But what happened, now there is a transition from Shah Bano to Daniel Latifi. We'll see a transition that this dual harmonization fades away, and that's what I'm going to argue now. So now I'll talk about the High Court judgments in the liminal period 1986 to 2001. As a result of huge uproar on the Shah Bano verdict in 1986, the Congress government implemented the Muslim Women Protection of Rights and Divorce Act. On the face of it, the short act seemed to protect the interests of not of Muslim women but Muslim men, as the provisions of the act debarred divorced Muslim women from accessing the secular law in section 125, which protects destitute women. This act seemed to free Muslim men from the obligation to provide lifelong maintenance to their divorced wives, which is safeguarded under section 125. However, it was only when in 1990s several appeals by Muslim men started accumulating against various High Court verdicts that the NWA caught the attention of legal scholars like Freya Agnes and Werner Minsky. This empirical reality suggested that the High Courts were interpreting the act in a way that prevented vagrancy and destitution of Muslim women. In this section, we look at the liminal period between 1986, when the MWA was passed, and 2001, when the constitutional validity of MWA was upheld in the Supreme Court. To probe how were the High Courts providing a gender-just interpretation of the Act, when on the face of it, the Act seemed to take away the maintenance rights of divorced Muslim women. In my analysis of High Court judgments, it shows that way before the Daniel Latifi verdict of 2001, High Courts used the Shah Bano verdict as a precedent to deliver gender-just verdicts. That is, these courts, in interpreting the MWA's provisions, followed a harmonization process found in the Shah Bano judgment. As such, majority High Courts did not construe MWA as a reversal of the Shah Bano judgment. Instead, the Shah Bano judgment became a basis for these courts to provide a gender-just interpretation of MWA. However, although the High Courts took the Shah Bano judgment as a precedent to be followed, they at the same time have departed from the judgment in a crucial way. In my analysis, I saw that the High Courts giving pro-women verdicts have reduced their reliance on religious exegesis to bring congruity between personal law and secular law. These courts instead harmonize the requirements of MWA with the secular law of the state by invoking social welfare concerns of the state present in the Act. In other words, the High Courts delivering gender-just verdicts have reduced their reliance on the kind of harmonization Mehta talks about, and have instead increasingly followed the harmonization process pointed out by Mensky. Thus, after the Shah Bano judgment and the promulgation of MWA, High Courts delivering gender-just verdicts hardly follow the dual harmonization process found in the Shah Bano verdict. It seems that Shah Bano controversy was a lesson for the Indian judiciary that reinterpretation of religious texts was not the best way to harmonize minority communities' personal laws with the general laws of the state. Now, we'll just quickly have a look at the table. 5 seconds. Okay, thanks. So this is the various High Court judgments that I analyzed. And if we see in the first column, reinterpretation of Quran, hardly any of the judgments except for the first one, and that too they quoted the Shah Bano judgment. None of the High Courts none of the High Courts involved in religious reinterpretation. Also, interestingly, invoking universal civil code is also not there. Nobody, except for the first one again, and that too they were quoting the Shah Bano judgment. Nobody invoked the need for a uniform civil code. So this is a pretty interesting case. That none of the High Courts are reinterpreting the Quran, but at the same time there is a harmonization of personal law with the secular law of the state. So now I'll just quickly move to the Daniel Latifi judgment, and then I'll just conclude some critical comments. The Daniel Latifi judgment of 2001. The Supreme Court in Daniel Latifi versus Union of India not only upheld the constitutional validity of MWA, but paradoxically also maintained that the Shah Bano case had been a good law, introduced for the welfare of Muslim divorcees, which is in consonance with Islamic principles and constitutional guarantees. In this paper, I have tried to argue that in the aftermath of the Shah Bano controversy, the Indian judiciary has increasingly relied on the state's social welfare concerns in order to harmonize the requirements of Muslim personal law with the general laws of the state. My examination of Daniel Latifi verdict demonstrates that the judiciary's increased reliance on welfare concerns has taken precedence over religious reinterpretation of texts. The judges in Latifi verdict did not feel the need to re-examine the requirements of Muslim personal law and whether it conflicted with the secular law. Rather, they maintained, and I quote, "In this case, to find out the personal law of Muslims with regard to divorced Muslim women's right, the starting point should be the Shah Bano's case and not the original texts or any other material, all the more so when varying versions of the authenticity of the source are shown to exist." End of quote. Thus, despite the controversy, the judges simply reaffirmed that Shah Bano case has rightly interpreted the requirements of Islamic law. The Shah Bano verdict then set a stage for an a priori assumption in the Indian judiciary that there is no conflict between Muslim personal law and secular state law, as both the moral imperatives of religion and legal requirements of the state are just the same. The Daniel Latifi verdict further attests to the patriarchal social reality in which women's lives are embedded and maintains that the provisions of MWA have been interpreted bearing this social reality in mind. And I quote the judgment, "In interpreting the provisions where matrimonial relationship is involved, we have to consider the social conditions prevalent in our society. In our society, whether they belong to majority or minority group, what is apparent is what is apparent is that there exists a great disparity in matter of economic resourcefulness between a man and a woman. Our society is male-dominated both economically and socially, and women are assigned invariably a dependent role, irrespective of the class of society to which she belongs. The judges opine that the societal problems of The judges opine that societal problems of vagrancy and destitution pertains to basic human rights and social justice. Therefore, they need to be decided on considerations other than religion. Thus, the judges clearly maintain that given the social reality, no matter what the Act's provisions are, the responsibility of maintaining the financial interest of divorces lies first and foremost with the husband. So, similar to other pro-women High Court verdicts discussed, this court also hinged on different phraseology of maintenance and provision in the Act to argue for lifelong maintenance for Muslim divorcees. The judges opine that nowhere has the Parliament provided that reasonable and fair provision, and maintenance is limited only for the iddah period and not beyond. Therefore, it extends to the whole life of the divorced woman until she gets married again. So I think I won't go on further about the Dania Latifi verdict. I'll just conclude quickly. In conclusion, I'll just give a critical assessment of the legal discourse on which the MWA is based. Sylvia Whattock's analysis of family courts demonstrates the pervasive paternalism that exists among judicial authorities, and she says that the pervasive paternalism that exists among judicial authorities hinders women's access to their rights. She remarks that assumptions of judicial authorities about a woman's nature, her proper place in society, and the notion that the institution of marriage is the only secure guarantee of a woman's well-being hinders a woman's access to civil court system. Imbued with such paternalistic attitudes, the legal counselors of the family courts, Whattock argues, and I quote, cannot but commit themselves to getting couples back together. In the context of family court negotiations, she points out that women are regularly encouraged to drop criminal charges against their husbands, to withdraw reduced property, maintenance or custody demands, and even to resume living with husbands who have subjected them to long-standing abuse in the past. While such paternalistic attitudes of judicial authorities will be faced by not just by Muslim women, but women of all denominations, Whattock's analysis provides a powerful critique to the legal discourse of MWA that Mensky celebrates. As we have seen, a gender-just interpretation of MWA is grounded in a discourse of welfare and protection rather than simply on a discourse of rights. Whattock's analysis shows that a legal discourse of rights that is transformed into a discourse of welfare, whose defining terms are set not by the woman herself, but by her counselor, her advocate, her judge, and by the realities imposed by the society in which she lives, can act as a barrier for a woman to obtain her legal rights. Thus, while the discourse of welfare present in the adjudication of MWA cases is salutary for Muslim divorcees, this same discourse of welfare can hinder women's access to their legal rights in the first place. So, I'll just end with certain questions. So then what are the limitations of such a discourse of protection then? Does it empower women, or does it produce dependent subjects? Does the use of such patriarchal norms for the benefit of derelict women embed patriarchy even further? Secondly, this discourse of protection shifts the burden of protecting vulnerable sections of the society from the state to the male family members of the society. What happens when such members evade or are unable to provide support to these vulnerable members? This discourse of protection, increasingly used by the judiciary to provide gender-just verdicts of MWA, needs to be looked at more critically to probe the extent to which it helps or hinders the rights of women. Thank you.